Good afternoon, this is Sean Golding with Golding & Golding, here to go through the basics of the very common question we receive often, which is what happens if I do not file my FBAR? Whether it's untimely, whether it's inaccurate, will the IRS penalize you, what happens next? Let's go through some of the basics. FBAR reporting and filing 101. U.S. persons who have foreign bank and financial accounts have to file. It's not limited to just bank accounts, which is a very common misconception. It involves bank accounts, investment accounts, pooled funds such as mutual funds and ETFs, pensions, retirement, life insurance, all shapes and sizes. FBAR reporting is for U.S. persons, but U.S. persons doesn't just mean individual. It also includes U.S. entities, trusts, corporations, partnerships, things like that. Whether it involves the IRS takes the position that even if like you live overseas in a treaty country and you make a treaty election to be treated as a non-resident, you still have to file it. But there's a case pending right now, ROS Day, where they're taking the position that they shouldn't have to file because they were living overseas as a non-resident alien under the treaty. When is the FBAR due? It's due April 15th. It's on automatic extension, which means taxpayers have to October. There is no formal mechanism currently to extend the FBAR. It's just on automatic extension. And it's filed electronically on the FinCEN website. FinCEN refers to Financial Crimes Enforcement Network, but it rarely, if anything, has to do with crime. So what happens if you do not file the FBAR? Well, depending on what you read online, you may end up in prison for 100 years with the special agents banging down your door, movie style. That rarely happens. There's a bunch of fear-mongering, scaremongering. Try to remove yourself from that nonsense. First, maybe nothing happens, right? You don't file the FBAR, and you never hear from the IRS. I mean, it's becoming a little less rare these days with FATCA and all the exchange of information between foreign financial institutions and the U.S., but there is a chance. And a quick aside, FATCA is the Foreign Account Tax Compliance Act. It's different than FBAR. Individuals file a Form 8938, so do other taxpayers. It's just with FATCA, there are hundreds of thousands of foreign financial institutions that are reporting U.S. persons who have foreign accounts and income to the U.S. government, and then this will impact FBAR. So they're two separate requirements. Most common, if penalties are going to be issued, they're non-willful penalties. Ever since the end of February 2023, the Supreme Court's ruling in Bittner severely limits the IRS's ability to pursue non-willful penalties. The IRS used to try to go after you for $10,000 per account per year. So for some taxpayers with several accounts over many years, it could be financially devastating. With the Supreme Court ruling, the IRS is limited to $10,000 per year. Typically, it's up to 6 years is the statute. It doesn't mean they're always going to get you for 6 years. Willfulness is bad, right? The IRS can claim you're willful either by showing intent, reckless disregard, willful blindness. The penalty could be 50% maximum value of the accounts, up to 100% within the compliance period. It used to be 300%, which would represent 50% penalty per year for up to 6 years, which is the statutory limitation. The Internal Revenue Manual makes it clear that the agent should not go more than 100% value for the compliance period. Not that that makes you feel any better. No warm and fuzzies with that. But IRS can mitigate those penalties. They don't mitigate them as much as they do with non-willfulness, but you can fight them, okay? Willfulness is a totality of the circumstance. There's no bright line test, and so it puts taxpayers, unfortunately, in a precarious position. Criminal penalties are even more rare. It's very uncommon to get hit with criminal penalties for FBAR unless it accompanies other issues such as money laundering, tax evasion, tax fraud, structuring, smurfing, things like that. Your grandma giving you an account you weren't sure if you had to report it is not going to land you in the big house. So please don't think it will, because it won't. If you have not filed your FBAR, you are not under audit, you're not under criminal investigation, the IRS has not contacted you yet, you have various different mechanisms you can use to get into compliance. The general term is called offshore disclosure. If you're willful or just can't certify under penalty of perjury that you're non-willful, you would typically do VDP, which is the Voluntary Disclosure Program, domestic and offshore. If you're non-willful, there's many other programs available. There's the streamlined filing compliance procedures, which include streamlined domestic and streamlined foreign, both for offshore accounts. It's just domestic is for U.S. residents, foreign is for foreign residents. There's also the delinquency procedures and reasonable cause. We have a ton of free information available on our main website and our sub-websites. You can always reach out and schedule a reduced fee initial consultation. It's appropriate to your matter, and it's something that we handle here. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.